Lortorios.
Hey guys, welcome to the Journey to Attorney podcast. I'm your host, El Elyon. Today this is my bar prep tea, and we'll be diving into actual and apparent authority. Basically, who can do what. And these are two of the biggest concepts when it comes to whether a principal is liable or whether their agent is liable. So if the bar exam gives you an agency question, there's a very high chance that this is what it's testing. Okay, so let's start with the big question. When is a principal bound by what their agent does? Now, there are two main ways that they can happen. The first of these is actual authority. So this is basically exactly what it sounds like. It's the real authority given by the principal to the agent, and it comes in what I like to call two different flavors. You have express authority and you have implied authority, all under actual authority. So it's actual authority expressly given or impliedly given. So express authority is pretty much when the principal straight up tells the agent what they can do. So this can be in writing or it could be spoken out loud. It's like, let's say my principal and I'm an agent, they come to me and say, hey Elion, can you go and sign the lease for the new office we're moving into on Monday? Or an email telling me to do the same thing. That is express authority, them telling me what to do. Okay, so when it comes to implied authority, that's where it gets a little bit more technical. There are three ways that implied authority can show up. The first of these is when it's necessary to complete a task. So let's say we'll use the example of running an event. You're running an event as a company and you tell your assistant, who is your agent, to run the event. They probably need to contact vendors, sign contracts, book venues, all of those things. If it's necessary for them to carry out those tasks in order to carry out the overall task of running the event, then the applied authority exists there. Okay, implied authority. It sounds like I said applied. Then you have past practice. So again, let's say it's an annual event and you run it often, and every year the agent is dealing with vendors, signing contracts, booking venues, paying the deposits. If that's what they've always done, or they've done it in past occurrences, and you're running an event again this year, and as the principal, you tell them, hey, make sure we run this event this year, do what you need to do. If it's based on past practice, that again is giving them that implied authority, and also kind of ties in with the necessity, right, to carry out a task. So the third way is more about industry customs. So if it's a custom within an industry, and again, we can use the event example, or a better example is, let's say, like a store, right? So if you have a general agent as a general store manager, and as part of the industry custom, whenever the stock is running low, they re-up, they stock up again, they do the orders that they need to do. In that case, it's custom for a general manager of a store to restock when the supplies are running low, right? So something like that could be linked to necessity. It could also be linked to past practice, but sometimes you'll see things that are more specific to industry customs. Okay, so also one other thing that you need to be aware of when it comes to actual authority is that even if the agent misunderstood what they were allowed to do, if it was a reasonable misunderstanding based on, let's say, a past practice, it still counts as actual authority. But that misunderstanding has to be reasonable. It can't be so far-fetched that the principal can say, well, why would you ever in a million years think that? Okay, so that's actual authority. You have express and you have implied. Now, moving on to apparent authority. This one's all about what the third party believes based on the principal's actions. Okay, so that's what you want to be looking at, the apparent authority. I know we touched on this earlier, but just to break it down in more detail, the rule is apparent authority exists when a third party reasonably believes that the agent can act on the principal's behalf, and that belief is traceable back to the principal. So in other words, the principal made it look like, or made it seem like, the agent had some kind of power. So that third party relied on the appearance of that power. So again, as an example, let's say you always let your assistant sign contracts for you when you're closing deals. If you tell her to stop signing contracts and booking these deals privately, but you don't tell the vendors or the people that you're working with, then in that case, those third parties will still think your agent has the power to do so. And that's apparent authority. So it's like, apparently this was your agent, right? You always bring her to the deals and tell her to sign the paperwork. So apparently that's your agent. How would we know otherwise without the principal explicitly stating that that person is no longer an agent? So this leads into when a principal is holding out as if the person is an agent, and there are different ways that a principal can do this. So one example is when the principal gives that person a title. So let's say you run a company, you have an agent working within the company, and you give them the title of Director of Operations, and it's on their LinkedIn, everybody upvotes it or celebrates it, whatever it might be, and it's public that this person is a Director of Operations for your company. You're holding them out and pretty much saying that this is an agent of your company. Another example is letting them sign deals in the past. Again, let's say you have this boardroom, and just as you're about to sign the contract, you say, okay, well, we've discussed all the details, all the nitty gritty. I'm going to go to lunch. Elion, you're the agent. You sign the paperwork, and you've always done that. Okay. So in that case, you're holding them out, you're leaving and saying, all right, take care of everything for them to sign the deals. In that case, you're holding that person out to have the authority to sign those deals on your behalf. And then on the flip side, if let's say you don't tell people that this person no longer has authority, but again, let's say boardroom setting, the deals are being signed, but you're just about to leave, and the agent who used to have authority is there, and you know they're not supposed to sign. Maybe you're testing them to see if they're going to sign, and you leave the room and they sign, but you didn't tell the third parties that they don't have authority. In that case, that's like holding out that this person has authority. So I'm giving you these examples because it's never just going to be, unfortunately, in the bar exam, you don't just get a question where you can just spit the law out and that's the end of it. They're always going to give you examples and scenarios. So just being able to apply your knowledge to the facts and analyze and come to a right conclusion is beneficial for you. So that's why I like to give examples and scenarios. Now, another thing when it comes to apparent authority is the identity of the principal. If it's the case that the principal is completely undisclosed, then no apparent authority can exist, because you can't rely on this image of power if you don't even know that there's a power force behind, right? If you don't even know that there's a principal behind the scenes in the first place. So if the principal is undisclosed and a third party thinks they're just dealing with an agent, it's just me and it's just you, in that case, then there can't be apparent authority because there was no apparently. It was just you as the agent and them as the third party. So watch out for whether they say that the principal is undisclosed and then think, okay, well, in this case, there is no apparent authority and the agent may be liable. All right. So really quickly, I just want to go over the 3 examples. So when you have a fully disclosed principal, everybody knows I'm the principal, everybody knows that's my agent, everybody knows that's the third party. In that case, the principal would be liable for anything that might arise because that third party knows who the agent was acting on behalf of. That agent was just the middleman, was just the messenger, and you shouldn't shoot the messenger. But if it's the case where the principal is partially disclosed, the third party knows there's a principal, they don't know who they are, they don't know who the company was, then in that case, there is a chance that both the principal and the agent could be liable in terms of upfront. Who am I going after? I'm going after the agent because I know there's a principal, but I don't know who that principal is. But then it gets more technical where you don't know who the principal is and you are trying to find out who to sue. The agent can always, and we'll talk about indemnification in the next episode, but the agent can always ask the principal to indemnify them, and we'll get onto that in the contractual liability episode. And then finally, when there is an undisclosed principal, as I've just mentioned, if the third party didn't know at all that a principal existed, then in that case the agent would be liable, and if there was actual authority, then the principal could be liable. But if you're seeing anything in the MEE that says they didn't know that there was a principal, you think, okay, this is an undisclosed principal. In this case, if there's liability, we're going to be looking at the agent. All right. So just to recap and hit those key points again, we have actual authority, which can be express or implied, where the principal is telling or implying what the agent can or cannot do. Then we have apparent authority, and that's based on what the third party believes based on the principal's actions. And even if actual authority is gone, apparent authority might still exist if the principal doesn't tell the third parties that the agent no longer has that authority. So make sure you have that clear and know the difference between disclosed, partially disclosed, and undisclosed principles. So just to wrap it up, going back to that LinkedIn example, right? Let's say this agent had posted on their LinkedIn, I'm the director of operations for this company, and the principal had previously cheered it. Let's say they go back to it and say, hey, you are no longer the director of operations for this company, remove this, shame on you, right? And a third party happens to see that post. In that case, the third party should know, based on the principal's actions, that that agent has no authority. So if they were to bump into them on the road and sign a contract that was pending, at that point, they should know, right? And we will go into this more, but I really just like that example because it gives you that full picture of what it looks like to be held out as an agent, as opposed to when a principal notifies the third party or makes it known to the public that that person is no longer an agent. So that's it for this episode. This is one of the most highly tested topics on agency, so make sure you're going in to those outlines, make sure you're doing those practice questions and just really getting a grasp of the concept, and more importantly, how those fact patterns are coming up and spotting those key issues. All right, keep at it. You're doing amazing, and as always, I'm rooting for you.
Lord Torio.